Welcome to Chapter 2, which deals with the fundamental rights and freedoms of employers and employees. Now, these fundamental rights and freedoms are contained in three main sources of law. The first one is the Constitution, the second one is the legislation, and the third one is the international law. Now, the Constitution. In terms of Article 5, the fundamental rights and freedoms must be protected by all organs of the state, that is the executive, the legislation, and the judiciary, and all juristic and natural persons in Namibia. Now, in terms of Article 8, every person, now that includes employees and employers, have the right to dignity. That's not to be subjected to torture or cruel or inhuman or degrading treatment or punishment. Now, in terms of Article 9, employees may never or no person may be subjected to slavery or forced labor. However, Article 9 does give exception for people who, for example, work in an emergency, police officers or soldiers who may be performing certain work that is required for security, and also people who are lawfully detained by the correctional service and may be required to perform certain acts as part or certain work as part of their rehabilitation. Also, it will not be regarded as forced labor if there is a court order that actually says that that person must perform such work as part of their punishment. Now, another fundamental right is Article 10, which deals with equality. It says that all people must be treated equally. So even in the place of employment, they may never be discriminated or must not be discriminated, whether on the basis of sex, race, social, or economic status. Now, we also have Article 15, which deals with children's rights. That section deals with the protection of children as far as employment is concerned. And for that section, children means people under the age of 16. So such people or children may never work under hazardous environments or dangerous environments. Then we have Article 21, which deals with the freedom of individuals. That includes the employers and employees. Now, it says that everybody has the freedom of association, which includes the freedom to form, join, or participate in activities of trade union. That's just to say that an employer may never stop an employee from forming or taking part in trade union. Then the same section 21 also provides for the right to perform any profession or trade. Now, apart from section 21, we also have section 23, which deals with apartheid and affirmative action. It simply states that the parliament or the government may come up with laws that actually seek to equalize Namibians when it comes to opportunities, and this includes opportunities as far as employment is concerned. Women, for example, there are also races where people were previously disadvantaged in Namibia. White people, for example, were more advantaged compared to black people. So laws that actually put previously disadvantaged people in a better position is not regarded as a discrimination, but rather as an affirmative action which tries to bring everyone on an equal footing so that they have the equal opportunity. Now, apart from the Constitution, we move on to legislations or acts that deal with fundamental rights and freedom of employers and employees. The first one is the Labor Act 11 of 2007. Now, Section 3 of that act provides for the prohibition and restriction of child labor. That has also been prohibited in the Constitution. Section 4 deals with the prohibition of forced labor, as also provided for in the Constitution. Section 5 deals with the prohibition of discrimination and sexual harassment in employment. So that is also a fundamental right. Then Section 6 deals with fundamental freedom of association, which is also provided for under the Constitution. And Section 7 deals with dispute concerning fundamental rights and protection, which simply provides that when those rights are violated, a person who is aggrieved may approach the labor commissioner. Alternatively, they may go directly to the High Court's labor court without having to go through the labor commissioner. Then we have the third source of law, which is international law. Now, the International Labour Organization has a declaration on fundamental principles. What this declaration provides for is that all states agree to adhere or protect the fundamental rights in as far as employers and employees are concerned. The number one is freedom of association and the effective recognition of the right to collective bargaining. Then, second, the elimination of all forms of forced or compulsory labor. Number three, the effective abolition of child labor. Number four, the elimination of discrimination in respect of employment and occupation. And number five, a safe and healthy working environment. Now, if you look at our Constitution and if you look at our Labor Act, the safe and healthy working environment does not fall under the fundamental rights, although you may interpret it as falling under, for example, Article 8, which deals with human dignity, and you can also interpret it to fall under the Labor Act section that deals with health and safety, although it is not classified per se in our labor law as a fundamental right. Now that concludes our lecture for the day. Thank you for listening. Please participate in your quizzes. Do engage on the question, which is the platform, and also please do submit all your assignments that you're required to submit. Thank you.